Good morning. Welcome to the seminar by Professor Kung-Chung Liu. And it's our great privilege and honor to be able to invite Professor Liu to give us this presentation. And during his very busy schedule, and he just flight in 2 days ago, and he's going to leave this afternoon. So it's very precious for us to have him here to share with us his research on balancing the interest of brand owners and secondhand markets of brand goods. Professor Liu is Lee Cheng Professor of Law, founder and director of the Applied Research Center for Intellectual Assets and the Law in Asia at the Singapore Management University. And he's also co-appointed by Renmin University of China and the Graduate Institute of Technology, Innovation, and Intellectual Property Management at the National Cheng University of Taiwan. Professor Liu have studied it at Taiwan University and also at the University of Ludwig Maximilian University of Munich. And he teaches includes intellectual property law, antitrust, and unfair competition law, and communication law. And he has been widely recognized in Europe and United States and China and Taiwan. And so let's welcome Professor Liu.
Okay. Thank you, Yang, for the kind introduction. It's good to be back again after 5 years at least to meet old friends and new friends. So my topic is just pretty much like Ling has written on her thesis about balance, but very specifically, how do we then balance the right and interest between owner of brand owners and also the so-called second-hand market for branded goods, which is actually emerging. And the reason why I chose this topic is actually because of Haochen, because Haochen is the expert on branded goods, luxury goods. Okay, and the second reason why I chose this topic is that actually this is a paper that has been just rejected by IID. This is something that really happened to me. They very much like my paper, but they say, probably, can you skip the part on corporate social responsibility? This is nonsense for IP. So, but I say, no, this is something new that we need to introduce. So I rejected their rejection. So, but I will incorporate this chapter, this article into my book. Hopefully I can finish this book by the end of May. Right. So just to give you a summary, and pretty much you have a rough idea about what I'm now doing. So I think it's important that we have a viable, sustainable, healthy second-hand market for everything. That is good for sustainable development, also for circular economy, which is very vital for our blue planet. But very importantly, brand owners, especially brand owners from well-known trademarks, they seem to be standing in the way. So especially the second-hand market for branded goods are under threat, so to speak, by the constant legal harassment by well-known trademark owners. And the trademark law, as we know it, doesn't provide any solution to this. And the antitrust law or anti-competition law is also a ill fit for fixing this problem. So my proposal here is that we need to go beyond traditional realm of trademark. We need to take a look into the so-called CSR and then introduce CSR into the realm of trademark, but not through legislative intervention that we write anything specifically into the trademark law. I think the judges, they can be the receivers of and usher in the new idea of corporate social responsibility. I think this is pretty much commonly accepted, and now it has evolved into ESG, but they are pretty much the same. And I think through the incremental introductions of CSR into trademark law, and we can strike the proper balance. And then what we have learned from the trademark law perhaps can be expanded to other area of IP laws as well. Okay, this is the theme of my talk. So pretty much I can close and say goodbye to you. But of course, I will not do that. I will just go walk you through a bit. So I will give you cases. It's important that we base on our theories on actual cases. But there aren't many cases. So I know for sure in Germany, in Europe, there isn't any cases that I'm going to talk about. So I will give you cases, and I would, based on that cases, I would try to have some reflections. And then again, this is a German lawyer typically do. We try to theorize. We try to put forward something in general, right? And then I'm advocating for setting up a third-party, neutral, so to speak, authentications institutions that is professional, independent, that can play a bridging role between the secondhand markets and the brand owners. So in order to achieve that, we need something creative, something new. I thought I was brave and creative enough, but I changed my mind after I read the Haochen's book, Technology and Public Interest, right? He's the real brave and innovative one than the old guy like me, okay? Right, so, but the reason why we have Article 21, TRIPS agreement, which does not allow compulsory trademark license, I think has to go back to the history to find the answer. I think that has to do with the imagined so-called monopoly phobia that was quite popular, especially in the 70s in the United States. But given the time constraint, I won't be able to go into the details. But there were actual cases in the Federal Trade Commission in the U.S., which the staffer, they put serious proposal to the commission. They try to fix the problem of monopoly by trademark owners through the introductions of compulsory trademark license. Okay, this is something that we have never heard of, but these are actual cases. There are two actual cases. But of course, I will not given time. I will not be able to go into the. Yeah, there are these two actual cases in the late 70s, where proposal has been proposed to the FTC, and both the administrative judge and the staffer, they thought that there are dominant trademark owners, and one way to break that dominance is through imposing compulsory trademark license, and that actually was very troubling for the U.S. or the industry, the trademark industry. So much so they decided to introduce Article 21 into the TRIPS agreement, which specifically and also weirdly disallow compulsory license of trademark. That has to do with this historical incident, right? Right, and then as I mentioned earlier, trademark, secondhand market is very important for sustainable development and also circular economy. But nowadays, secondhand market for branded luxury goods become very, very popular among youngsters. I don't know. So, but there's a huge market, and it can also even be vintage collections. There are people who just collect all this and resell all this. Right. But as I mentioned, then the success and failure of secondhand market for branded goods pretty much hinges on the fact that whether they can authenticate their products as genuine, right? But as a common practice, brand owners, they only keep everything to themselves. They don't teach any other third party about how do you authenticate these goods at dispute. No, they keep everything to themselves. So then, and then they go into great length in establishing very complicated way to secure the authenticity of their product. For example, then they will only sell through authorized dealers, okay, and they have to be specifically approved, and then they even designate the point of sale, okay, and assign every product actual serial numbers, okay, and then set up all kinds of internal recording system, which is very difficult for outsiders to trade, and they have very exclusive manufacturer doing the actual productions for them, and only to very limited quantity. All this just to secure that this is a genuine product, right? But then they, as I mentioned, they don't train any third party outsider. They only do this exclusively themselves, and so they then can say, "Well, anything other than me might be fakes, and it's only we can authenticate the authenticity of these products." And my paper deals exclusively only with secondhand products as they are, okay, without refurbishment, okay, without remodifications, or what they call upcycling. Okay, you made something out of this the bottoms, for example, of Chanel, and then for making artifacts out of this. This is what they call upcycling. This is not what I'm dealing with. I'm just dealing with the simple resale of pre-owned product as they are. Okay, okay. There are many criminal cases related to well-known trademark that also had to do with the second-hand market. So I just did a very preliminary search in Taiwan, for example. As of last year, LV has filed 204 criminal cases related to trademark. And then Hermes 59, the Gucci 129, and the Chanel 123. Okay, and these are the following are the four actual cases that went to trial. Okay, so one is 2008, which involved 4 Hermes bags. The typical practice is then Hermes sue criminally first. After winning the criminal case, then they started to sue the criminal case. In this case, just for 4 alleged counterfeit bags, the poor lady was sentenced to 6 months imprisonment with 3-year probation. But the monetary fine is exorbitant. It has eventually the court asked this poor lady to pay some 50 million renminbi for selling these 4 bags. Okay, this is a bit complicated, but I don't have time to go into detail, right? And then in 2017, LV brought another civil lawsuit over 4 bags. But then there was a dispute whether these bags at the dispute are fakes or genuine. So both parties have then retained their experts. Okay, the defendant retained someone from Hong Kong. I don't know if you know this Milan Stations, which seems to be a popular website for secondhand branded goods. And then the plaintiff, LV, they then appoint their IP manager, who is a specialist in doing all these authentications. And then without any surprise, both parties come to the direct opposite conclusions. Plaintiff saying that, of course, these 4 bags are fake. And then the defender, the extra witness of defender said, no, these are genuine. Okay, then the court is then faced with a dilemma. Which side is more credible than the other side? Then eventually, the judges, although he confessed that both are actually foggy in their argument and their reasoning. But the court has nothing, eventually has no choice but to believe what the LV has said, because they are closer to the actual manufacturing or this. But the judge pointed out the danger of doing this in a systematic way. And then there's another 2020 case, which not only one cheap wallet, okay, by LV, and the case went all the way up to the Supreme Court, and then this is very, very interesting case. So two ladies, they bought a bag and they don't like the bag, and they resell this on the Shopee. And then immediately after receiving the bag, the buyer alleged, well, this is a fake. So the buyer claimed, asked for a full refund, and the seller refunded the whole price immediately. Okay, so there was no damages whatsoever. But then the alleged buyer sued them criminally, alleging that they are selling counterfeits online and making profits out of online business. Okay, and then the whole process started 3.5 years along the way, and then these two ladies was found guilty of selling counterfeit. But the two ladies, in defense, they said, no, we're selling genuine goods. But again, then the LV stepped forward and said, well, guess what? These are fake. Okay, and then although LV is not the actual seller and buyer in this case, but then the seller settled, so to speak, settled with LV and make public apologies and even provide the kind of damages to LV. And then eventually these two ladies was then sentenced to imprisonment for 1 year and 4 months without probation. And then they appealed, and the case was due to bid 1 year and 1 month, but with probation. So the whole ordeal went on for 3.5 years, just for selling one alleged fake bag of LV bag. Okay, then another case, 2022, as I mentioned, it's just a very cheap the used wallet, okay, was bought in Japan from the website Brandia. And the case was found guilty and went all the way to Supreme Court. Then the court revoked the decision, and the Supreme Court, the MF Court, was very uncomfortable with the blind trust in the assessment of the plaintiff. Plaintiff said, well, this is fake, but the plaintiff refused to go into detail by what criteria have they then come to the conclusion that these are fakes. And the Supreme Court said, no, this is something very disturbing. You have to at least ask them, how do they come up with this final decision that these are indeed fake product? Okay, so then if these cases keep going on, then people will feel very unsafe and threatened if they do go into the secondhand business of branded goods in Taiwan. We also have some very limited cases in the US. So then I don't know if you know this very well-known website, The Real, okay? They emphasize very much that they are selling real products. But different from other secondhand resellers, they take extra efforts to ensure the authenticity of their products. Okay, so they hire a professional, and they give internal training, and do all this. They try to improve the secondhand market for branded goods, so that fakes will be removed out of the market. But nevertheless, they were still sued by Chanel for alleged for selling the allegedly selling the fake product. But then the courts are also facing with the same dilemma. So which side is more credit than the other side? Okay, and then the case started in 2018, and it is still pending today. But the real file counterclaiming saying that, well, Chanel is really doing all kinds of anti-competitive campaign against resellers, and there was serious accusation, and that's why the case was suspended for a period of 3 years. But then both parties couldn't agree, so now they continue their legal fight. And then Chanel also sued another second-hand reseller. What goes around comes around. Right. So Chanel typically don't allow other third parties to do these authentication. They do all this internally, and they always proclaim to the public that only Chanel itself can know what is genuine, what is not. Okay, insinuating that any authentication by other people cannot be true. Okay, you can only buy from us. Right. So the mention the real brings a serious counterclaim for antitrust, anti-competitive behavior, all kinds of exclusionary, anti-competitive conduct. Right. So it is dominant, so to speak, because these brands, especially for buyers who have pay expensively for their product, they are, so to speak, locked into the Chanel world, and in that regard, and to that extent, Chanel does enjoy the dominance over the buyers. Okay, so the authenticity is the cornerstone for secondhand market, right? And they do try to innovate and renovate the second market to make it more trustworthy, transparent, reliable. But they are not accepted. They are not recognized by brand owners. They will sue for selling counterfeit. Then another case I mentioned, what goes around comes around. This case was decided through summary judgment. So at the end of the day, it was again, this is innovative secondhand resellers. They try very bad to ensure that these products that they sell are genuine, not fakes, but still they are sued by Chanel. So the case was decided through a summary judgment. Yet then the court found that WGACA liable for trademark infringement, but not counterfeit. Okay, so you have to distinguish between trademark infringement and counterfeit. Counterfeit is then willful infringement on a commercial scale. And so in this case, then we see them, well, the goods are actually genuine. But the only problem is that, well, it is not sold to the designated point of sales. That makes it illegal. Okay, but the product is genuine. And then there are some bags. These are actually genuine bags made by the authorized manufacturer. But guess what? The serious numbers are stolen from the factory. Okay, and there are several bags. They use pirated serious numbers, but the product themselves are genuine. Okay, so the brand owner, they have a very sophisticated systems of making sure that whatever that has not went through their official channel run the high risk of being identified as fake. Okay, and these are things that we outsider cannot really track. Okay, intractable. So then I think there are issues of trademark bully by brand owners. So especially in Taiwan, we see they just bring the criminal charges for very small number of bags and charge astronomical compensations. I think this is indeed bullying, right? So then. And they're also pushing the envelopes of their right. So if the brand owner like LV and Chanel can eventually prevail, actually they are creating a new right for them, authentication rights for themselves, which has no legal foundation, right? So the exclusive right of trademark right does not include the authentication right at all, and without legal foundation. And this right is timely unlimited. Okay, so temporarily unlimited. Wow, so then it will never exhaust or expire. So that is a very dangerous trend. Okay, and then there are also unfair competition related issues because they insinuate, well, only we can. So other people, whatever they do, they cannot be genuine. So this is really hurting the industry. And also, as I mentioned, there's the issues of abuse of pure market power relating to SME resellers, right? They don't have deep markets like the brand owners, right? So then I think we do need a third-party independent authentication institution that can play a bridging role between brand owners and the second-hand market. Okay. And there are economic and legal justifications. For legal justification is quite obvious because then you cannot let this happen all the time. I mean, you cannot let the plaintiff to be the judge of their case at the same time all the time, right? So it's clearly against the principle of rule of law. You have to have a neutral third party to really to decide the difference. And there are even stronger economic justification why we need to have this kind of third-party mechanism, because actually it will help the brand owners rather than hurting the brand owner. Because if you have a viable second-hand market that can sell a product, that people can buy product with confidence, then people will have more money to buy the first-hand products. So if you keep buying first-hand products, but you cannot resell them, that will be a disaster for you. But so if it will be a healthy circular economy, so that if you can easily resell your pre-owned product, and then you get some money back, and then you can justifiably and ask your wife to agree. Now I can have more money. I can buy a new one. So that will enhance a first-hand market in the mid to longer term. So that is even more stronger than the legal justifications, right? But then there are legal hurdles why people will frown upon the idea. So what do you mean setting up a neutral third-party mechanism? First of all, there were issues of a trade secret. So these third party must then have access to the trade secrets of brand owner. So why on earth should the trade owner convey the trade secret to these so-called neutral third party? But that question has been asked again and again in the context of brand licensing of SDP. So until today, no one knows what trend really looks like. I don't know, because every licensing agreement is under confidentiality principle clause. So we don't simply have access to these licensing agreements. So no one knows the licensing terms and conditions. And then this is what we are now. Everyone is talking about brand licensing of sex. Basically, they're only talking about nonsense because no one really have read. Even if they have read any licensing agreement, they are not allowed to talk about. They are all subject to confidentiality. Are we going to live a life like this that keep chasing after our tail and we're looking for frame compliant terms, but we never can read, have access to any terms and conditions? And I think similarly, we found ourselves in a situation where we just blindly or unconditional surrender to the so-called trade secret protection needs of brand owners. Then they can dictate the life and death for the second-hand brand market. Right. So then, I don't think trade secret protections is an obstacle that we cannot overcome. Okay. So then, how do we then find a legal foundation? Then I have to admit, current trademark as we know it, or competition law or unfair competition law, are ill fit. Okay. But I don't really have time to go into detail. Competition is unsuitable because it is just one-off. It is only for asking people, prohibiting people from doing anything, but rather than asking people to do something positive in a longer term. So competition law is also an ill fit. So in that regard, I think CSR can play a very important role. Okay, so that idea was introduced by Howard Bowen in 1953. So over time, I think generally it has been widely accepted. So then I can give you cases where actually statutory law recognized CSR. So in China, for example, both its company law and its civil code recognize CSR. And Indian Company Act also specifically recognize CSR, and they ask big company to set up CSR committee to spend 2% of their average net profit on issue related to CSR. So they become legal institution rather than altruistic appeal. And in Taiwan, then if financial institution follow CSR principle, they will get preferential treatment by the financial oversight agent. And also, EU is asking about 50,000 companies to make annual report on their execution of CSR. Right? So, but I have to again admit that in the context of IP, we haven't talked much about CSR, and except Haochen, okay? So the first one that I can find is actually Abby Brown, okay? She's an Aussie, okay? And then in 2005, she talked about so-called socially responsible IP. But the way she talked about it is not in a binding force or in a binding form, but rather, again, altruistic. So today, it is true that no consensus within the IP community that we decided to accept CSR into the family of IP. No, very sporadic talk about this. But ATRIPS, the world-renowned association of teachers of IP, they started to talk about this topic seriously last July in Tokyo. Right. Okay. So then I see this need reaching out, not just limited to trademark, and then I also find similar approach taken by two very famous European trademark scholars. Okay, so Aneta Kuhl in her wonderful paper about refurbishing. Selling refurbished product, and she said, well, so if I refurbish and remodel some goods, so a good made by brand owners, and then I have to then declare this, and in that context, I can also use my own brand in addition to the original brand, and that kind of combinations of use, according to her, is entirely justifiable because it is clear, transparent, it's not leading, and I think she actually has incorporated the idea of preventing unfair competition in the realm of IP trademark. Right? And another very famous trademark scholar, Martin St. Leben, he's now teaching at the Amsterdam University. Okay, and he then talked specific about the urgent need for change of productions and consumption pattern. Okay, that's why his paper is about advocating the legality of so-called upcycling. Okay, so I take a bottom made from LV, but then I put it on bags. And these kind of so-called upcycling should also be allowed according to him. So these are all people very trademark heavyweight, reaching out beyond traditional trademark domain, looking at the bigger pictures of environment, of sustainability, and about the circular economy, about unfair competition. Okay, so then I think courts can play a pivotal role in introducing DSR into trademark. Okay, and we don't really need to have legislative intervention. And then court can really balance things out. So they, if, for example, there are expectations that we expected of resellers. And first of all, is that they don't guarantee that what they sell is 100% genuine. There's no such thing. No one can make that kind of a guarantee. And what is the best, at best, it's an educated guess, okay, assessment. But it's best for them not to do this kind of advertising. And they should, in addition, I mean, resellers, they should undertake measures to set up this kind of that they should develop or delegate a process and employ trained experts, of course, according to their the size of their business. But SME retailers, they can achieve that through collective efforts. So the industry can set up authentication center or agency themselves, and they should also develop industry-wide standard for best practice, so that the second-hand market for branded goods can be transparent, reliable, trustworthy. And there are also expectations expected of brand owners. Okay, they can still stick to their own decision, the original decision. They just keep everything to themselves. Okay, they will do all the authentication themselves internally, but they have to show us that there is indeed a guarantee for the independence and trustworthiness of the internal authentication reports. People working for LV are truly independent, okay? And their promotion, their salary will not be affected by their determinations of the products and dispute. Their salary, their promotion, all this shall be independently from normal employee. This is a rather difficult thing to achieve, okay? So if the brand owner plaintiff continue to assert absolute protection of its trade secret, I will not disclose anything. And they try to completely shield the authenticity appraisement from external scrutiny, then it would be certain that the plaintiff should be awarded a losing verdict. If they cannot, if the other side, the defendant successfully deny the independence and trustworthiness of the appraiser appointed by the brand owner. So you have to set up you have to meet a very high threshold. And if you fail to meet that high threshold, then you cannot say, well, guess what? This is my trade secret. I will not disclose. I will not reveal it. And this is my right. You should protect my right. This will not be accepted. And if brand owner continues to resort to courts in similar cases, criminal cases, and the selling of fake, again, they trouble court, like with this kind of accusation, then CSR, the corporate social responsibility, would further expect brand owners to proactively support independent third-party authentication agency. Okay, because it is actually in your own benefit. And courts are helpless in solving this kind of dispute. So you cannot just ask court to do the thing and you fix it on your own hand, right? So then, with the setup of a neutral third party, then of course this agency will have access to the trade secrets of brand owners. But this is only in the hands of a few people with the true expertise, and they can surely guard the secrecy of those valuable information correctly, right? And then in return, actually, the help is not it's not without remunerations. So brand owners, when they proactively help third-party authentication institutions, they also can charge them for a fee, right? So not that they are doing this for altruistic purpose. No, they are really helping building a sustainable, viable, healthy second-hand market, and that will actually, in turn, help the growth of the first-hand market. But we need some intervention so that brand owner can overcome their own short-sightedness. Everything has to happen in short term. You have to show me you are good, but no, I don't have time to wait for you. Just to write as many papers as possible, right? Every one of us here is following this short-termism. And brand owner, they are acting like this as well. But you just talk to them and convince them, no. Helping others is really helping you. Okay, this is what competition law is all about. But if you are a brand owner, you are an IP owner, you are blinded by your own self-interest, short-term interest. But we need the intervention of competition law so that you will be brought to your own senses. Okay, so then I think potentially CSR can be introduced to a trademark through cases adjudicated by court. Okay, court can then play a very important gatekeeper, the role of a gatekeeper, and we don't really need legislative intervention. We don't need to have a very detailed legislations, and don't we trust court and judges? Actually, they are the receivers and conveyors of social perception about CSR. These are the actual receiver and conveyors. And then through the actual application, through cases, we can then accumulate experiences in the trademark area, and then have and that actually CSR, I think, can keep trademark law abreast of the call of our time. We cannot be indifferent to the call of our time. We cannot possibly allow things to go wasted, right? And use. It's only in our own interest that we allow goods 物尽其用, that they will be used to the maximum, so that our human society can be more sustainable. Trademark law cannot turn a deaf ear and blind eyes to the call of our time. With the introduction of CSR, we can respond to the call of our time. And then what has happened in trademark can also be incrementally expanded to other area of IP. So IP, as we know it today, will be very different from next generation to see it in 20 years time. Okay, trust me, it will be very, very different. Okay, so that's a wrap up pretty much what I've been reading. Although it has been rejected by IIC, which has never rejected my paper. Okay, I think that points out the potentiality, the potential of this topic. Okay, thank you.
Well, thank you very much, Professor Liu. for your very insightful, comprehensive, and thoroughly enjoyable talk on this very complicated topic. We are going to have a real expert comment on Professor Liu's talk. Let's welcome Professor Tung.
Thank you, Professor Liu, for this wonderful talk, and thank you, Professor Li, for hosting it. And I have been writing and teaching and publishing on this topic, so I'm very delighted to join this panel discussion to share my thoughts. And I thoroughly enjoy Professor Liu's talk. I think we only have 15 minutes left, right? So I need to be really short so that we can leave some time for Q&A. I'll be very quick. So there are things that we have to bear in mind when it comes to luxury brands. I think the first thing we need to bear in mind is what constitutes luxury or a luxury brand. This is something that I talk with my students when I teach this so-called trademark protection of luxury brand course. By the way, if you're interested, feel free to take it in the future. So I rely on my article titled University as a Luxury Brand, which was published a few years ago. So in that article, I proposed that we need to have basically two ideas, fundamental ideas to understand the concept of luxury or a luxury brand. One is the idea of exclusivity. Owners of luxury brands, are different from owners of normal brands. They wish to, achieve exclusivity through, for example, the quality of the goods, through the, innovative design, and through higher prices. So this is something we need to bear in mind. There are different elements contributing to exclusivity, and exclusivity of luxury brands, is different from the normal brands we have been seeing every day. Okay, and then we also need to bear in mind the idea of conspicuous consumption. Luxury or a luxury brand does this social phenomenon. In the very, very old days, conspicuous consumption of luxury goods really means goods. People use, so-called luxury goods, high, special or precious materials, gold, diamonds, that decorate their houses, their, clothes, and many other things as well. But starting from the last 5 decades or so, or even a little longer, conspicuous consumption mainly deals with conspicuous consumption luxury brands. We're moving from luxury goods to brands, luxury brands. So that's another function of luxury brands. We rely on brand itself to show off their our wealth or social status. So these are the things that we have to bear in mind when we talk about luxury brands. Okay, and so there is, so these two things that we need to protect when it comes to trademark protection of luxury goods, to maintain and enhance exclusivity of brands, and we try not to bring up this kind of conspicuous consumption of luxury brands as well. Okay, so I'm talking about things that we should do in order to protect brand owners' interests, right? But then there comes Professor Liu's paper and talk. He thinks that luxury brands or luxury goods should be made available to more people in the marketplace through the used goods market, right? Okay, you can resell luxury goods. But on the premises that these goods are genuine, they're not fake goods. If fake goods are circulated in the marketplace, that will, harm luxury brands' own interest. Okay. So then the reselling part, in my opinion, is the part of your proposal, how we should maintain it, at the robust market, so that we could, enhance consumers' interest. At the same time, I think you indicated that, or implied that we could also protect luxury brand owners' interest, because, as you pointed out, that while people can resell their luxury goods, right, which means that they can further buy more luxury goods. But then there is a question here, I think. Luxury goods company might not necessarily want to see a vibrant second-hand market, right? It might not do so good to their, for example, the exclusivity of brand, with all kinds of quality issues, right? Fake goods involved. They instead, brand owner want to see that they wanna, people will buy goods in their, for example, in their shops or their online, platforms. Okay, and so there is also a concern that the more goods that luxury goods that reach out to more people, it will ultimately make luxury brands not that exclusive. Okay, so there's a balance we need to strike, although it's always hard to strike a balance, but not reaching everybody, right? Okay, so we need to strike a balance. I think this is also luxury brand owners' concern. And I share the concern that we need to consider consumers' interest as well. And then there comes, the concept of public interest that, I've been writing about, and as you pointed out. But then I want to ask you a question before we move on to talk about corporate social responsibility. So why do we need to care about consumers' interest in the reselling market? I mean, ordinary consumers who buy second-hand luxury goods. What benefit can they obtain? Why do we need to protect such consumers' interests? Put it differently, do people necessarily need to have luxury goods? What if they don't buy luxury goods? Will they die? Or will their well-being really be reduced? They could, luxury goods are replaceable goods, right? They're not kind of necessity goods, right? Okay. So I don't think people necessarily need to, possess or use luxury goods, right? So if people do not possess, many of ordinary, non-luxury good consumers, if they are not allowed or they cannot afford luxury goods, what are the, what are the harms that have been caused to the consumers? And why do we need to protect such so-called, consumer interest as part of the public interest? So this is the first question I want to.
Can I reply?
Sure.
Okay. I don't know about you, but I buy my first watch, my first anything valuable second, right? So take Rolex for example. If my father just bought me a Rolex, I will just know I will not appreciate this. But I save money. I survey the market, and then I make the best buy, and I know everything, every detail about Rolex. And this is how we really normal people. I'm not I'm from a rich family, so normal people buy their first used car, right? Secondhand car, a secondhand house, a secondhand watch, everything secondhand. This is our normal way of living. And secondly, this really will really make the best use of the life of the product, the life cycle of product that will be put to the maximum use. That will help conserve the resources for our human being, right? So you can say, of course, that no one will die if they don't wear Rolex, but
the planet will perish if everyone just keep buying new thing and keep throwing things away as if it was just made for one. No, we should. So I have no problem when I go to the state, for example. I just rent everything from a secondhand for my furniture when I was in Stanford. So when I first came to Singapore just a month ago, I had no problem buying secondhand. This is how I protect our environment.
Okay, so I think it would be great to specify the different kinds of public interests involved in the reselling market. So I'll be let me quickly move on to the corporate social responsibility part. I think really need to be very quick. So I think it's a great idea, but I have a bit reservation. The first reservation is exactly what I talked about earlier. Why do we need to have such a mechanism as you propose, have an independent institution to deal with the authenticity of goods? So why it is necessarily good for the kind of public interest that you wish to protect in the reselling market? I think in my own opinion, we could have broader conception of SCR and when it comes to luxury goods, companies. For example, many years ago, I published a paper in UC Davis Law Review in which I advocate that we should require luxury goods company as a social responsibility to distribute brochures about poverty the kind of poverty like children, many children in the least developed world have been suffering, or many other things that we could do. For example, luxury goods company have been destroying goods if they could not sell them. You probably have heard stories about that. So my question is, why just independent institution to deal with the authenticity of luxury brand or luxury goods? We could do much more than we could. Okay, I'll be very quick. I think I just need 1 minute to finish. The second question about scale of economy. So I wonder how many disputes will there be when it comes to the authenticity of luxury goods? You just mentioned quite a number of, or a few cases involving such needs, but compared with the number of cases of disputes and compared with the cost of establishing such an independent institution, I wonder whether it is totally makes sense to invest so much money doing so, or we just rely on courts. Luxury goods company can, when they launch litigation, they can supply information about authenticity of goods, right? And the court can decide at that point. So just on an ad hoc manner, I would say maybe more pro scale of economy. And then for this kind of independent institution, I wonder whether that will necessarily will adequately protect brand owners' interests. As you mentioned, there's a concern about trade secrets. Luxury goods companies might not necessarily wish to share the trade secrets. For example, how to make their handbags, watches, how to detect inside, or basically how to deal with authenticity. I mean, once such information is shared with an independent institution, that gives rise to the risk that there will be a further leakage of such trade secrets to any other parties. So I hope that we could come up with a mechanism to prevent at least trade secrets from being leaked. So there will be a necessity of this, ensuring non-sharing of trade secrets. Thank you. Thank you very much.
Okay, thank Professor Tung for very critical comments. Professor Liu, you want to respond to the last question?
Okay, very quickly. I think it's commonplace that we need all kinds of third-party neutral mechanisms to do all kinds of oversight, especially in this interconnected world. So take algorithm, for example. Algorithm designs our daily life like crazy. But the operator of algorithm, they know everything about us. We know nothing about them. So how do we solve this issue? We need a neutral, trustworthy third-party agency to do this job for us, algorithm auditing. And the AI development, again, the U.S. is accusing China, and China is accusing the U.S. So which side shall we believe? We need globally workable, neutral, trustworthy third party to play this very important role. Okay, and for brand owners, really, what they can really do to protect their exclusivity is through the continual effort to maintain the quality. Although the number will be increasing significantly, but that is the magic. So if you can maintain a constant quality throughout years and scaling it up, this is the real recipe for success. So LV, Chanel, they can do all their marketing gadgets. They don't really need to rely on these so-called trade secrets. Okay, give it one good example. Din Tai Fung, for example. Din Tai Fung is the most popular dim sum restaurant globally, right? They publish all their recipes. There's no secret recipe for them. No. The real tricky thing is that how do you then manage the quality consistently and while scaling it up? This is very difficult to achieve. If you manage to do that, you can be a brand owner yourself.
Okay, I think this is a very rare opportunity for having Professor Liu with us. So I think the audience will eager to ask questions. But because of the time limit, we only take 2 questions. Will that be okay? Okay.
Thank you for the very provoking. I think like one of the answers to whether a third-party authenticator is, I think, aside from that, I think like we can learn from the art world. Say, for example, providing for provenance. They will always such thing beforehand and certify such real, because if they have a chain of provenance, then in that sense, that such thing is real. Right. And the interesting thing about my concern about DSR is in fact because usually DSR is usually related to say corporate responsibility to a certain social cause. Say for example, as I know, Chanel donate a lot of money to say look in Hong Kong, for example, to NGO called Her Fund as a way to grow family. But at the same time, we all know that it's for tax deduction. But at the same time, if they do that part of DSR. But like going back to Professor Sun's concept, I think luxury goods is about, as Marx would say, a use a symbolic value, sorry, but not so much on the environment or SDG of the use value of that. So in that sense, like I think like if there is a third-party authenticator, then or adjudicator, they have to be not only third party, they have to be a non-partisan NGO as well, or else if they are profit making, then that would be a huge problem. And my final comment would be, I'm all curious that whether these brands will put their fight to say big auction houses like Christie's or so on, because they have their own in-house authenticator or specialist. Or are they willing to cooperate, or they will just bring the fight to them because they think that their authenticator is not as good as their own?
Okay, do you like to respond this? Okay, the second question.
From general aspect, law is about lowest standard,
Mhm.
and social level is about higher standard, higher standard. How could it be reconciled for a court? And we can technically, before going into social value for those companies and going back to antitrust, the teachers have taught something called essential facilities doctrine. Luxury brands reserve it to themselves. It is a unilateral refusal of license, unilateral refusal refuse dominant power. Could this be possible? Trademark, trademark. I believe it has to be very much patent.
Yes.
Essential standard type about
Yeah,
general.
right. Yes. So a quick answer to your second question is that I think that is entirely possible, at least in theory, to apply antitrust law to brand owners, even in the realm of trademark. And coming back to your first question, CSR used to be indeed higher standard. People look up to it, and people just talk very admirably about CSR. But now it has been instrumentalized, it's become part of the legal system. So everywhere you look, CSR or ESG compliance will be the top priority for companies. So they come down from the heaven, not become part of the earth. They are now part of the legal system. But then coming back to his question, then CSR traditionally must target a more specific target, so that you want to sponsor justice or you want to sponsor feminism, I don't know. But here specifically, I think trademark can appeal to a circular economy, because trademarked goods are being manufactured in massive quantity, and many products made by a brand owner will be destroyed after they have ended the selling periods, simply because they want to keep this artificial exclusivity and rarity. That is a bit insane in the long run, especially we don't have long run, because the earth is burning right now. We must save our planet. So I think appealing to a circular economy is one good point for CSI, the area of trademark.
Yes, it's already overrun, so I might give a big part review, and also at the same time, and also your own participation. Very much.